Hi again. So for this video, let's talk about the state. So the state is a politically organized sovereign community, independent of outside control, bound by penalties of nationhood, legally supreme within its territory, acting through a government functioning under a regime of law. It is thus a sovereign person, with the people composing it viewed as an organized corporate society under a government with the legal competence to exact obedience to its commands. It has been referred to as a body politic, organized by common consent for mutual defense and mutual safety, and to promote general welfare. It is both a legal and political concept. So, to be recognized as a state, a country must comply with the following requisites. First, it must have a politically organized sovereign community independent of outside control, bound by penalties of nationhood, legally supreme within its territory, acting through a government functioning under a regime of law. Second, it must be a sovereign person, with the people composing it viewed as an organized corporate society. Third, it is a body politic, organized by common consent for mutual defense and mutual safety and to promote general welfare. And it is the juridical personification of a nation. So, para simple lang, kasi yung mga in-enumerate ko, parang describe niya na yung characteristic ng state, pati yung purpose kung bakit inorganize yung state. Pati yung capabilities and powers of a state. Pero para i-simplify natin, the essential elements of state are, apat yan. First, people. Kailangan syempre may tao na nagko-compose sa state. Kasi, kaya nga may state para i-represent yung people sa international community and para, kumbaga, yung mga tao, yun yung dahilan kung bakit may state. 'Di ba? So, it's really composed of people. And the people should be numerous enough. Hindi pwedeng state ka tapos 10 tao lang kayo dyan. It should be numerous enough. So, yung state, mas malapit siya sa term na country kaysa sa government. Kasi yung country, di ba? Pag sinabi mong country, ando na lahat. May people. And also, may territory. So, yung state, isang element niya rin, yung second element niya is territory. Siyempre, kailangan ng sarili niyang territory kung saan nandun yung mga tao niya. Hindi pwedeng wala siyang territory. Hindi pwedeng group of persons lang siya. Kasi pag group of persons lang siya, edi parang organization lang yan, diba? So, meron siyang area na kanya talaga, na may jurisdiction siya, na i-exercise niya within sa territory niya yung powers niya. Next is government. Yun yung third. Yung government, yun yung nag-govern sa people. Yung sa atin, syempre, yun yung Philippine government natin. Yun yung composed of the president, yung cabinet niya, yung buong administration niya, yun yung government. Gino-govern yung mga tao. Pero also part of our government is the legislative and the judicial departments. So, ayun, may territory. Sa territory, merong mga tao, yung mga tao governed by a government. And lastly, sovereignty. Pag sinabi mong sovereignty, yun yung independence niya. Hindi siya masasabing state kapag parang colony lang siya. Dapat may sarili siyang laws, hindi siya controlled ng ibang countries or ibang states. Meron siyang nire-recognize internationally as an independent entity. May sarili siyang governance. So, yun yung apat. People, territory, government, and sovereignty. Pero, i-discuss natin isa-isa later na parang mas at a deeper level. So, recognition by other states, however, is not a precondition to attain the status of statehood. While it is ideal, it is not required. State ka na kapag meron kang people, territory, sovereignty, people, territory, government, and sovereignty. It is also ideal for a state to have attained a certain level of civilization, but it is not indispensable. Ano ba yung ibig sabihin natin civilization? Civilized, hindi siya merong educational system in place, merong, alam mo yun, civilized, hindi barbaric, hindi parang mga animals lang tayo sa wilderness. Hindi gano'n, hindi mga Tarzan dyan at mga unggoy, literal mga tao. So, dapat ideally may gano'n, civilized. Kaso, hindi siya requirement. Tapos pag sinabi mong civilized, di ba para sa akin parang ang napaka-subjective, no? Pero, ayun. There is no requisite as to the number of people as long as the people comprising the state must be capable of sustaining their existence, which comes from both sexes for perpetuity. So, ideally, um, may sufficient number of males and females kasi para may perpetuity, may continuity. Kasi kapag ka puro lalaki dyan, 'di ba? Like parang paano na. Pero may mga exception kasi like for example, Vatican. Sa Vatican kasi most doon mga lalaki kasi yung mga nakatira din doon, 'di ba? Ang liit ng population nila. Pero yung mga nakatira din doon, parang mga empleyado din ng Roman Catholic Church. Tapos ayun. Pero ano naman yun parang hindi yun yung normal. Parang, parang sabihin na nating special kasi yung Vatican. Kasi, although na ang liit ng territory, ang liit ng mga tao, and mostly lalaki, pero somehow, di ba, it's a religious institution as well. Tapos yung congregation niya is not just composed of the people within Vatican, but rather all over the world, 'di ba? So it's quite different. Pero yung usual kasi, yung mga normal lang na mga states or countries, 'di ba? Um merong population composed of both male and female. Ganon. The people must, however, be numerous enough to be self-sufficient. So, pag konti lang kasi, parang hindi mo siya masasabing state kasi, the state, lahat ng yan, di ba? Paano mo ma-maintain yung territory mo? Paano mo i-run yung government mo? Dapat may sufficient number of people. Pero walang nire-recommend na kailangan may ganitong number of people or ganitong population. Wala namang requirement na ganon. Basta self-sufficient lang. Economically, di ba? Merong mga industries, merong mga trabaho, merong nagbibigay ng trabaho, yung ganon. Tapos, syempre, self-sufficient, kasama na rin doon yung being able to defend the state. So, kailangan meron ka ring military, ganyan. Tapos yung peacekeeping mo pa within the state, di ba? Kailangan meron ka ring kapulisan, mga ganyan. Pero hindi siya pwedeng sobrang laki na parang sabihin mo buong Southeast Asia. Kasi it has also to be small enough for it to be easily administered and sustained. And the people must inhabit the state. And the people that inhabit the state, paano ba? The people that inhabit the state, dapat, permanent. Medyo permanent. Yun. Bakit ko sabing medyo? Dapat permanent. Dapat hindi in passing lang or transit lang yung mga tao within its territory. Dapat citizens na ito. So pag sabi mong citizens, meron siyang concept of permanence. Dapat may mga taong gustong magstay sa territory na yon ng state. Gustong doon magtrabaho, mag-start ng pamilya, yung gano'n, may permanence ba? Hindi pwedeng parang daanan lang siya ng mga tao. Like sure may mga tao pero lahat naman yan citizens ng ibang states. Hindi pwedeng ganon. Dapat para state ka, yung people mo talaga. Yung yung people na yon may sense of permanence na hindi sila basta-bastang umaalis. Parang doon sila nag-establish ng domicile at residents nila sa territory mo para masabi mong subjects, quote-unquote, mo yung mga taong to. Kasi pag yung subject kasi na term, parang more siya sa monarchy di ba? Pero, ayun, citizens of the state, ganon. So, anong kinaiba naman sa nation? Yung nation kasi, it's an ethnic concept. When you say nation, it's the people bound together by common attractions and repulsions. Parang they share the same history. They are possessed of common pulse, intelligence, inspiration, beliefs, and yun nga, parang ethnic concept siya kasi nation usually it's in relation to birth or origin and implies a common race. So, the Filipino people, mga Pinoy yan, di ba? And ano yung Pinoy? May mga pare-parehas na features. May, Asian, hindi siya Caucasian. And parang, same, yun nga, it's a racial concept. It's, when you say nation, it's a racial or ethnic concept. Pero meron namang mga states na parang hotpot, parang sa atin din naman, 'di ba? Hindi naman puro Filipino lang. May mga ibang lahi din dito na citizens din, ganyan, or mga mix, ganyan. Wala namang problema 'yan. Pero 'di ba, parang yung dominate is mga Pinoy din talaga. For example, pag sa China ka naman, mga Chinese naman yung mga tao din, they share the same features. Yung race nila, 'di ba, Chinese, yun yung nationality nila. Kaya mas sinasabing nationality, pag sinabi mong nationality mo Filipino, it's because part ka ng Filipino nation, which is a racial and ethnic concept. 'Di ba, pag may mga sinasagutan tayong forms, iba yung nationality sa citizenship. So, pwede kasing yung nationality mo ganito, which would indicate your race. Pero citizen ka of a different state. Like, pwedeng citizen ka ng Canada, pero yung nationality mo is Filipino. So, yun yung nation. Meron naman, yun nga, for example, United States of America, na parang mix-mix na talaga yung nila. But, nationality nila, yung nagdo-dominate din naman is of course kapag United States of America ka, American, diba? Tapos, yung citizenship mo, America. Pero, yun nga, when you say nation, yung sinasabing people kasi sa state, more siya sa citizens, sa citizenship, hindi siya sa nation. Pero, syempre, yung nation, yun yung, for example, mga Filipino, yun yung mostly nagiging citizens rin ng isang state. I hope that makes sense. Pero magkaiba yung nationality sa citizenship, magkaiba yung nation sa sinasabing people of the state. So, citizens. Sino ba yung citizens sa Philippines? So, according to Article 4, Section 1 of the 1987 Constitution, those who are citizens of the Philippines at the time of the adoption of the 1987 Constitution, those whose fathers and mothers are citizens of the Philippines, kasi sa atin, jus sanguinis tayo Pag sinabi mong jus sanguinis, di ba, parang yung jus sanguinis na to, pinag-uusapan to, pa lang elementary pa lang, di ba, sa araling panlipunan or HECASI or whatever it is that you call that subject now. So, yun, by blood. So, pag yung parents mo, Filipino citizen, wala ka nang kailangang gawin, Filipino ka na pagkapanganak mo. Yung other naman kasi jus soli Like, kung yun naman by location. Like, for example, sa US, pag pinanganak ka sa US citizen ka, regardless of the, blood of your mother or your father. Those born before January 7, 1973 of Filipino mothers who elect Philippine citizenship upon reaching the age of majority. Bakit Filipino mothers? Kasi walang question kung yung mother mo Filipino at alam mo yun, yung anak niya, no question na Filipino din kasi in terms of like, 'di ba, napag-usapan natin sa nung pinag-uusapan natin yung family code sa civil law, walang question kapag naanak ka ng nanay mo kasi galing ka sa kanya. Pero medyo sometimes merong doubt as to the paternity kung sino yung tatay kasi 'di ba? Hindi naman yung tatay mo naglawal sa'yo. Pero yung nanay mo, sure talagang nanay mo yun kapag may baby pictures ka. So anyway, ayun. So, kaya mothers, of Filipino mothers. Lastly, those who are naturalized in accordance with law. So, pwedeng hindi ka Filipino by blood, pero maging Filipino citizen ka through the process of naturalization. Okay, so pause muna tayo. Okay, so government. The government is an element of the state, as mentioned. It is an agent that externalizes the state and articulates its will. It's an institution or aggregate of institutions by which an independent society makes and carries out those rules of action which are necessary to enable men to live in a social state, or which are imposed upon the people forming that society by those who possess the power or authority of prescribing them. Yung gobyerno. Public corporation. Those formed or organized for the government of a portion of the state. Ano naman yung municipal corporation? So ito yung LGUs natin, municipal corporation yung tawag sa mga yon. It includes organized cities, towns, and like organizations with political and legislative powers for the local and civil government, and police regulations of the inhabitants of the particular district included in the boundaries of that corporation, of that municipal corporation. It also has the authority of government of the inhabitants of a particular place or district and authorizing them in their corporate capacity to exercise subordinate specified powers of legislation and regulation with respect to their local and internal concerns. So it's twofold in character really. It's the public government and at the same time it's corporate property. Bakit municipal corporation yung tawag? Kasi, well, hindi tayo mag-corporate law, corporation law ngayon, pero ano ba yung corporation? It's a juridical entity that, it's a juridical person that has rights, that can purchase property, that can own property, for example. So, yung City of Manila, meron siyang properties na nakapangalan sa City of Manila na hindi necessarily nakapangalan sa Republic of the Philippines. Yung City of Manila, meron siyang kanya na territory, meron siyang properties na kanya na iba sa sa Quezon City, for example. Or, yung latest issue ngayon, Makati at Taguig. Yung Makati City siya, municipal corporation siya. Yung Taguig City or City of Taguig, same din, municipal corporation din siya. So, 'di ba may mga dispute sila as to territory? Kasi sasabihin ni Makati, akin yan. Sasabihin ni Taguig, akin to. And meron property si Makati, merong property si Taguig. Parehas silang nasa Pilipinas, parehas silang iisang, Philippine government, pero may kanya-kanya silang tao, may kanya-kanya silang territory, may kanya-kanya silang government, local government, may kanya-kanya din silang ordinance. Maaring iba yung ordinance sa Makati, iba yung ordinance sa Taguig. May iba-iba silang rules na kapag nandun ka sa Taguig, bawal mo to gawin, pero pwede mong gawin sa Makati, vice versa. May mga iba-iba rin silang uri ng taxes, 'di ba? So, para rin siyang corporation, para rin siyang mini states din at the same time, pero hindi mo siya matatawag na state. Yung municipal corporation, hindi siya state. Yung state is as a whole. Yun. Kasama yung Philippine government na yung central government natin, yung nandun sa Malacanang, tapos, by the way, yung sa Malacanang at Malacanang yung palace, Malacanang yung complex. Pero anyway, yun, meron tayong central Philippine government, meron din tayong mga local government units, gaya ng mga cities. Hindi lang cities pwede ding municipalities. Meron din province na concept. 'Di ba yung province, ano yan, 'di ba? Um, may barangay ka, 'di ba? Pati yung mga barangay nga, 'di ba? Parang ganun din. May barangay, tapos meron kang district or town, tapos meron kang city or municipality. Yung city at municipality parehas lang 'yan. Kaso yung city, yung isang municipality pwedeng mag-achieve ng cityhood kapag may na-meet siyang mga certain requirements in terms of like income, yung people niya, so ganyan. Pero anyway, same lang yan. It's either municipality ka or city ka. Tapos, part yan lahat ng provincial government, 'di ba? So yung province, minsan may pagmamay-ari din siya na kanya na iba doon sa city or municipality na meron siya. Basta ganon. GOCC naman, lagi nating naririnig GOCC. Yung ibig sabihin nito is government-owned or controlled corporations. So GOCCs, private in character to, pero they promote certain aspects of the economic life of the people and may take on the form of a private enterprise, yes, or one organized with the powers and formal characteristics of a private corporation under the revised corporation code. So kahit private siya, pero yung purpose niya usually for a public purpose. So Government of the Republic of the Philippines, ito na yung central government. An entity of the government through which the functions of the republic are exercised as an attribute of its sovereignty. And in this are included those arms which political authority is made effective, whether they be provincial, municipal, or other forms of local governments. So what is a de facto government? So yung de facto at de jure government, huwag tayong ma-confuse. Walang tama or mali sa kanila. Both to, yung de facto government and yung de jure government, both are kinds of defective governments. Kasi merong misconception na yung de facto yung mali, yung de jure yung tama or yung legit. Hindi. Both a kind of defective government. May kakulangan sa de facto government, may kakulangan rin sa de jure government. So sa de facto government, it is a kind of de facto government. It is a kind of defective government. And it usually exercises power of control but without legal title. Yung de jure government naman, a kind of defective government that has rightful title but no power of control. So see, magkaiba sila. Sa de facto, may control, walang title. Sa de jure, may title, walang control. So, pag-usapan muna natin sa de facto. It is one established in defiance of the legitimate sovereign. The three kinds of de facto governments are yung in-establish through rebellion, pwede rin through occupation, or pwede rin through insurrection. So, de facto governments established through rebellion are governments that get possession and control through force, or pwede rin voice of the people, and maintains itself against the will of the rightful government. So merong government, tapos yung tao gustong mag-ano ng bagong government, so merong rebellion or pwede din through force, like may nag-invade dyan, tapos sila yung may actual na control, pero in terms of title, yung may rightful title, meron namang government in place. So yung nag-usurp na yun yung de facto government. Wala siyang legal title, pero meron siyang control. Established through occupation naman, it is established and maintained by military forces who invade and occupy a territory of the enemy in the course of war. So, yung tawag din dito is government of paramount force. So, pag nagwa-war, pag may in-invade, tapos sila yung nagkaroon ng actual control over the territory and its people, then de facto government yan established through occupation. Kasi parang nagiging useless yung rightful government kasi wala naman silang control talaga. Yung in reality, oo, sila yung legitimate, pero in reality, iba yung namamalakad, kumbaga. And lastly, established through insurrection. It is established as an independent government by the inhabitants of a country who rise in insurrection against its parent state. So yung mga tao mismo, they organize themselves to oust the government, for example. And they actually succeeded in gaining power. Kaya sila yung naging de facto government. Kasi kung wala kang power, kung hindi ka naman nag-succeed, kung nag-attempt ka lang, hindi ka masasabing de facto government. Kailangan nag-succeed ka. De jure government, a kind of defective government that has rightful title but no power, either because the same has been withdrawn from it or because it has not yet actually entered into the existence thereof. So, at a point, nung time na, di ba, meron tayong government headed by President Ferdinand Marcos, tapos nag-martial law siya, nung time na nag-people power, tapos na-install si President Cory Aquino as the new president, 'di ba? It's contentious issue, wag na nating pag-usapan. Pero nung na-install siya as president through people power, yung government niya at that time, nung hindi pa parang established talaga, de jure government. Kasi parang pumasok siya, pero hindi pa talaga siyang naka-install doon na without question. Until naging actual government na talaga natin siya nung, you know, pumunta na sa Hawaii yung mga Marcoses, and then inaccept na ng mga tao pati ng international community yung government ni Cory Aquino. So, from the jure government, naging ano na siya, hindi na siya defective government, naging legitimate government na siya. Okay, so belligerent occupation, also known as military occupation. It presupposes a hostile invasion as a result of which has rendered the invaded government incapable of publicly exercising its authority, and that the invader is in position to substitute or has already substituted his own authority for that of the legitimate territory invaded. Such occupation must be both actual and effective, and it shall have the following effects. Again, dapat effective siya, kasi kung hindi naman siya masasabing kailangan mag-succeed. So the exercise of sovereignty shall be suspended, and the rightful legal government has no control over the government and cannot enforce its political laws, and the political laws of the occupied territory are suspended subject to revival under the doctrine of Jus Postliminium. Thus, the members of the rightful legal government are still bound to obey the political laws of the rightful legal government. So, ano yung Doctrine of Postliminium? It is the personal power of the state over its nationals, which may be exercised by the state even if the individual is outside the territory of such state. So, pag citizen ka ng Philippines, meron pa rin siyang power over you kahit wala ka sa territory ng Philippines kasi citizen ka niya. The Articles of War, which is a political law, shall continue to be effective during the time of the belligerent occupancy, and the municipal laws cannot generally be abrogated by the invader and remains effective during the belligerent occupation. So, pag-usapan muna natin siguro yung political laws and municipal laws. So, political laws prescribe the reciprocal rights, duties, and obligations of government and citizens. They are suspended or are in abeyance during a military occupation. So, municipal laws naman governs the domestic aspects of the government and deals with issues between individuals and administrative apparatus. So, principle of Jus Postliminium, at the end of the occupation, when the occupant is ousted from the territory, the political laws na, 'di ba, nung time na may belligerent occupation, may mga military forces na pumasok. For example, Japan, 'di ba? Nung inoccupy tayo ng Japan, at that time hindi natin ma-exercise yung political laws natin kasi sila yung may control eh. Wala tayong magagawa. So kahit na meron legitimate Philippine government at that time, wala tayong magagawa kasi na overpower tayo ng Japanese military. Pero sa time na aalis na sila, yung political laws na supersede during the occupation, wala nang kailangan gawin, automatic, effective na ulit. Effective na ulit yung, back in business na ulit yung Philippine government. So ano naman yung administration? Composed of group of persons in whose hands the reins of government are for the time being. It is the administration that runs the affairs of the government for a period of time. So, gaya ngayon, we are under Marcos administration nung nanalo si Bongbong Marcos. Kasi, yung government, andyan lang yan, permanent, hindi yan nag-iiba-iba. Yung administration, yung mga tao composing the government. So, nung nanalo si Bongbong Marcos as president, 'di ba? nag-iba na yung cabinet secretaries, yung department heads, yung department secretaries, undersecretary, kasi ina-appoint niya lahat yun, di ba? So, yung mga in-appoint niya, lahat, Marcos administration, sa leadership niya. Before sa kanya, pero yung Philippine government, andyan lang yan. Before sa kanya, Duterte administration. Before sa Duterte administration, Aquino administration. Gets nyo? Yung government andyan lang, pero yung mga tao nag-iiba-iba kung sino yung nagpapatakbo. Yun yung administration. Constituent function of the government constitutes the very bonds of society and are compulsory in nature. These are exercised by the state as attributes of sovereignty. However, the traditional functions of the government are now considered obsolete because of the growing complexities of modern society. Ministrant function of the government, undertaken only by way of advancing the general interests of society and are merely optional. So, Parens Patriae literally means parent of his or her country. So, it allows the state to step in and serve as the guardian for the children, the mentally ill, the incompetent, the elderly, disabled persons, yung mga minority or mga nangangailangan ng assistance ng government who are unable to care for themselves. And the government, as guardian of the rights of the people, may even initiate legal actions for and in behalf of these people. It is a prerogative that is inherent in the supreme power of every state. Whether that power is lodged in a royal person or in the legislature, as in our case, and has no affinity to those arbitrary powers which are sometimes exerted by irresponsible of their liberties. So, Parens Patriae is the most beneficent function and often necessary to exercise in the interest in the interest of humanity and for the prevention of injury to those who cannot protect themselves. Parens Patriae, isipin nyo lang parent, di ba? Okay. So, sovereignty. After ng sovereignty, I'll take a break and then territory naman. Isa-isahin natin yung elements ng state. So, sovereignty is the power granted to the state to govern its affairs. So, it's permanent, it's exclusive, it's comprehensive, it's absolute, it's indivisible, it's inalienable, and imprescriptible. So, legal sovereignty is the power to issue final commands, possession of unlimited power to make laws, and the authority by which a law has the power to issue final commands conferred upon the Congress. Political sovereignty is the sum total of all the influences in the state which lie behind the law. It is roughly defined as the power of the people. It is the sovereignty of the electorate or the whole body politic conferred upon by the people by themselves. Internal sovereignty is a supreme power over anything within its territory, the power of the state to control its domestic affairs within sa Philippines. External sovereignty is known as independence. Nire-recognize tayo ng mga ibang countries or ibang states. It's the freedom from external control. It is, may power tayong mag-negotiate, may power tayong mag-attend ng meeting sa international, mga international conventions, ganyan. May power tayong i-represent yung interest ng Filipino people. And kailangan nilang i-respect yon. Hindi tayo kinokontrol ng ibang bansa. It is the power of the state to direct its relations with other states. So, ayun. Sovereignty, parte ng state, magkaiba yun sa government. Yung government kasi, yung affairs natin, yung sovereignty, ito na yung parang bakit natin kailangan sundin yung batas? Saan galing yung power ng state para ipakulong yung mga tao kapag may violations ng law? 'Di ba? Yung reason, hindi government. Kasi yung government mechanism yan para patakbuhin yung affairs ng state. Yung power na yon, yung hindi natin nakikita, 'di ba? Hindi natin mahawakan. Pero bakit tayo sumusunod? Sovereignty, yung sagot diyan. So, kasi bakit ba natin sinubject yung sarili natin sa ganito? Hindi na lang tayo parang, we can do whatever we want, 'di ba? May pinatay kang tao, anong masama doon, 'di ba? Like, I mean, oo, masama siya, yes, morally, Pero merong iba siguro nag-isip okay lang kasi total yung unang panahon, 'di ba? O hindi ka naman nakukulong pag may pinatay ka, parang survival of the fittest, eme. So, bakit ganun? Bakit sinubject natin yung sarili natin sa mga batas? Bakit tayo nagbabayad ng tax? Dahil may sovereignty, 'di ba? And give up ng tao, nag-agree yung mga tao na okay, para hindi na magpatayan yung mga tao, para mas marami tayong magawa, mas magtulungan na lang tayo. Paano tayo magtutulungan? Ibig sabihin pag magtutulungan tayo, magfo-form tayo ng society, 'di ba? I-give up natin yung ibang rights natin para in exchange of, hindi ka nakakabahan. Dati kung walang state, 'di ba? Paglalakad-lakad ka lang dyan sa labas, di mo alam papatayin ka, 'di ba? Na bad trip lang sa sinabi mo, or nag-agawan lang kayo ng isda dyan, or inani niya yung palay mo. Alam mo yon, mga ganong bagay. Parang mga animals lang, 'di ba? Wala na tayong ganung kaba eh. Kasi, although meron, pero alam natin na pag may ginawa tayo sa ibang tao na masama, may consequence yun, makukulong tayo. 'Di ba? Pagbabayaran natin kasi merong pulis, merong gobyerno, may nagbabantay, may tumitingin. So, meron tayo, we're feeling safer kasi we're availing of the benefits of having the police. Tapos hindi na tayo kakabahan na bigla na lang tayong papasukin dito ng China kasi meron tayong defense, meron tayong military, meron tayong armed forces of the Philippines. May mga ganun na bagay na parang feeling mo protected ka. So makaka-move on ka sa buhay, makakapag-aral ka. Pati yung pag-aaral, self-study ka na lang ba? Ngayon meron tayong schools, 'di ba? Kung wala kang pera, mag-private school, merong public schools. May mga ganong opportunities tayo for growth and development and being a civilized nation because of, the state. And the state has the power to do all those things, has the authority to do all those things because it has sovereignty. So yung pag-uusapan naman natin ngayon is territory. So what is territory? Territory is the fixed portion of the surface of the earth inhabited by the people of a state. So as for the Philippines, it is defined in the Article 1 of the 1987 Constitution, where it consists of the Philippine Archipelago and all other territories over which the Philippines has sovereignty or jurisdiction. Yung kailangan nating tandaan dito is Philippine Archipelago and all other territories. Meaning, pwedeng hindi siya nasa Philippine Archipelago as long as other territories over which the Philippines has sovereignty or jurisdiction. So, yun. Basta, mas okay na i-memorize natin yung Article 1, yung national territory, para, alam mo yun, mas matandaan natin. So, yun. So, memorize nyo yun, yung Article 1. The 1973 Constitution claims historic or legal title of Sabah and Borneo. So, kahit yung Sabah at yung Borneo, kahit wala sila sa Philippine Archipelago, pero by historic or legal title, kino-consider natin silang territory, so part sila ng territory natin as far as we are concerned. The Treaty of Washington granted Cagayan de Sulu and Cebuto Islands to the Philippines. The Treaty of Great Britain granted the Turtle and Mangos Islands. Tama ba to? May Mangos Island ba? Baka mali yung notes ko. Or manganese or something. Feeling ko manganese. Mangoes. Baka nag-ano na naman. Baka nag-autocorrect na naman. Or, tama ba? Wait lang. Nakakahiya kasi kapag mali tayo. Turtle and Mangsi. Oh my God. See? Mangsi. Ano mangoes? Ba't mangoes? Turtle and Mangsi. Ay, naku, autocorrect. Okay. The Turtle and Mangsi Islands to the Philippines. The 1935 Constitution includes the Batanes Island group as part of our territory. And modes of acquisition of territory are occupation, accession, cession, and prescription. So, by the way, mag-upload ako ng video on property law soon. So, ayun, i-discuss natin yung modes of ownership doon. So, Archipelagic Doctrine. The waters around, between, and connecting the islands of the archipelago, regardless of their breadth and dimensions, form part of the internal waters of the Philippines. So, andito to sa yung sinabi ko, nandyan yan sa Article 1 of the 1987 Constitution. So, under this Archipelagic Doctrine, a straight baseline is drawn connecting the outermost points of the archipelago and considering all the waters enclosed thereby as internal waters. So, for example, Pilipinas yan. Mag-draw ka ng baseline sa mga outermost edges na yan. Yung loob niyan, internal waters ng Philippines. So, ano ba yung archipelago? An archipelago is a group of islands including parts of the islands, yung land masses na maliliit, yung mga isla-isla, and the interconnecting waters. So, pag sinabi mong archipelago, baka iniisip nyo yung lupa lang, yung islands lang. Hindi, pati yung waters nun, part yun ng archipelago. And other natural features closely interrelated to such islands, waters, and other natural features form an intrinsic geographical, economic, and political entity, or which historically has been regarded as such. So, internal waters, ito yung waters around and between and connecting the islands of the archipelago, forming part of our national territory. These are waters of the landward side of the baseline of the territory. So, since archipelago tayo, hindi tayo gaya ng, say, Canada, for example, or China na isang chunk of land, or Russia na parang pak, siya, isang lupang yan. Yung sa atin, maraming katubig-tubigan, diba? Kasi isla-isla siya. So, yun na yun. Parang kasama yun. Isang chunk lang yun. Yung kahit na pakalat-kalat na mga isla plus may mga tubig-tubig sa gitna, isang unit lang yon, yung archipelago na yon. Territorial Sea, belt of water immediately surrounding the country's landmass, hindi siya internal waters. So, 'di ba, ito, for example, ano ba? Ito. For example, tong phone ko. Bale, 'di ba, may mga isla. Tapos may mga tubig diyan. So, yung mga yan, isang unit yan, 'di ba? Yan yung internal waters, yung sa loob na. Pero yung tubig naman outward, meaning sa labas nun. So 'di ba may isang unit na ganyan, yung archipelago. Yung sa labas nun, yun yung territorial sea, basta mag-count ka ng 12 nautical miles. Yung 12 nautical miles parang, isipin nyo lang para siyang mile pero sa tubig. So 12 nautical miles from the baselines. So it is 3 miles from the low water mark. Contiguous zone naman, which adjoins or borders the territorial sea of the country, which is 24 nautical miles from the baseline. So imagine nyo, ito, tapos may 12 ka dyan, yun yung territorial sea, yung nakapalibot na tubig, sa atin pa rin yan, territorial sea natin yan. Tapos another 12, dagdag ka. So for example, 12, tapos papatungan mo ng another 12, so yung total niya is 24 from the baseline. So ganyan, contiguous zone na yan. So, yung buo niyan, ibig sabihin yung territorial sea, part siya ng contiguous zone. Kasi 'di ba 12, 12, imagine nyo, tapos magdadagdag ako ng isa pa. So, doble. So, 24 na yan. So, yung itong buong to, contiguous zone. Yung itong part na to, yung half niya is yung territorial sea. So, yun. Pati yung waters dyan na nakapaligid sa atin, hindi lang yung nasa loob na water, is part of our territory. Now, yung exclusive economic zone, it's a marine area including the sub-adjacent seabed and subsoil, pati yung sa baba. Diba? Hindi lang yung surface ng waters, pati yung sa baba. Beyond and adjacent to the territorial sea, extending up to 200 nautical miles from the baseline. So, ibig sabihin, 24 yan, diba? So, magdadagdag ka. Mag 200 minus 24 ka na lang, pero, you don't have to do it. Basta, yung buong exclusive economic zone na yan, 200 nautical miles from the baseline. So, ibig sabihin yung territorial sea natin, yung contiguous sea natin, part rin siya ng exclusive economic zone. So, ano yung pwede natin gawin sa exclusive economic zone? Other states may enjoy freedom of navigation and overflight. Hindi sinasabing, di ba, part ng yung territorial sea at contiguous zone, part ng exclusive economic zone, pero, may mga iba-iba kasing rights yan. hindi ibig sabihin na yung other states may enjoy freedom of navigation and overflight over our territorial sea. Hindi. Yung ibig sabihin it's 200 minus 12 or 24, di ba? As a case may be. Hindi siya yung right ng other states to enjoy freedom of navigation and overflight. Pwede sa exclusive economic zone natin, pero hindi siya pwede sa pinakaloob. Hindi siya pwede sa territorial sea, hindi siya pwede sa internal waters. Wala silang ganong freedom na basta-basta na walang conditions na ini-impose yung Philippines. Pero outside the territorial sea, outside the contiguous zone, sure. So, the coastal state has the sovereign right of exploring, coastal state tayo yon. Mayroon tayong right of exploring and exploiting, conserving and managing the natural resources, living or non-living, within the waters of our EEZ. The coastal state has the right to establish and use artificial islands and structures, and the coastal state has the right to conduct marine scientific research and to protect and preserve the environment. So islands have the objective capacity to be assessed and is capable to sustain permanent human habitation and economic activities and is entitled to full maritime zones. Rocks cannot sustain human habitation or economic life on their own, and these are disqualified from generating maritime zones. So yung islands lang, yung rocks iba naman yan. Artificial islands, installations, and structures. The coastal state, tayo, shall have the exclusive right to construct, authorize, and regulate the construction, operation, and use of artificial islands, installations, and structures for the purpose of protecting its rights, jurisdictions, and duties, and for exploring, exploiting, conserving, and managing its natural resources in the exclusive economic zone. The coastal state may also establish safety zones around the artificial islands. However, it must not interfere with navigation of recognized sea lanes. These zones do not possess the legal status of islands. These zones also cannot generate a territorial sea of its own and have no effect in the delimitation of the coastal state's territorial sea. So, normal baseline method. Low water line along the coast marked on large-scale charts, officially recognized by the coastal state. It is where the seawater meets the temporary shoreline created during low tide and starting point for measurement of the 12-mile territorial sea. So yung ginagamit natin is the straight baseline method. The state laying claim to the territorial seas draws a straight line from the selected points along the shoreline. The state may enclose its land territory within straight lines connected to each other. The drawing of the baselines must not depart from the general direction of the coast and must theoretically not exceed the 12 nautical mile limit. The baselines either follow the curves, bends, and sensuosities of the coast or are established by drawing arcs of circles from points along the low water line. Archipelagic baselines. Baselines join the outermost points of the outermost islands and drying reefs of the archipelago, provided that within such are included the main islands and an area which the ratio of the water to land, including atolls, is between 1:1 and 9:1. The length of such baselines shall not exceed 100 nautical miles, except up to 3% of the total number of baselines enclosing any archipelago may exceed up to the max length of 125 nautical miles. Drawing of such baselines shall not depart from any appreciable extent from the general configuration of the archipelago. It shall not be drawn to and from low tide elevations unless lighthouses or similar installations are permanently above sea level have been built on there, or where a low tide elevation is situated wholly or partly at a distance not exceeding the breadth of the territorial sea from the nearest island. So, mas maganda sana na drawing, pero yung mga textbooks natin, pati yung mga ibang reviewers, meron yung drawing dyan. Basta yung point is yan. Tapos meron mga points dyan. Actually, merong Republic Act na nagde-designate kung alin dyan yung mga points kung saan i-draw yung baseline. So Continental Shelf, seabed and subsoil of the submarine areas that extend beyond its territorial sea throughout the natural prolongation of its land territory or to a distance of 200 nautical miles from the baselines from which the breadth of the territorial sea is measured, where the outer edge of the continental margin does not extend up to that distance. It must not exceed 350 nautical miles. High seas. So yung high seas, di ba meron tayong 200 nautical miles na EEZ? Beyond that, yun na yung high seas. So res communes yan. It's not territorial sea, hindi yan internal waters, hindi yan archipelagic waters or archipelagic sea. Lahat, pag-mamayari ng buong mundo yan. Walang nagmamayari, so pwedeng access ng lahat. Ganun pala, hindi pagmamayari ng buong mundo. So yon. It is reserved for peaceful purposes and no state may subject any part of it to its sovereignty. Kaya yung piracy, 'di ba, is a crime na committed sa high seas. Kapag yung piracy commit sa high seas, saan mo pwedeng i-file yung kaso? Saang court? Kahit saan. Kasi yung piracy is considered as crimes against humanity kasi doon siya sa high seas, 'di ba? Lahat andon. The high seas accorded, kasi bawal kang magka-jurisdiction doon sa high seas. So, sino, meaning lahat pwedeng mag-try ng case. Ganon. So, bawal may umangkin ng high seas. The high seas accorded the following freedoms: freedom of navigation, overflight, lay submarine cables and pipelines, construction of artificial islands and other installations permitted by international law. So, hindi naman sila pwedeng basta-basta lang mag-create dyan and stuff dahil walang may nagmamayari or dahil sa walang may nagmamayari, pagmamayari ng lahat. 'Di ba? Pero, may international law pa din na kailangang sundin. Like, meron tayong United Nations Convention on the Law of the Seas, mga ganyan. So, or UNCLOS. So, pwede pa silang mag-enter into treaties and conventions, di ba? Anyway, hindi natin pag-uusapan ng international law kasi it's another thing that, mahaba din na discussion. It's a separate subject, but part siya ng political law, yes. Pero sa ngayon, stick muna tayo sa Consti law. Fishing and scientific research. A warship may not board a foreign vessel unless there is reasonable ground for suspecting that the ship is engaged in piracy. Di ba? Kasi bakit pwedeng foreign vessel ka, bakit pwede mong pasukin na parang pulis ka dyan, tapos huhulihin mo, sasabihin mo na pirate sila dyan, ganyan. It's because it's a crime against humanity. So, pwedeng i-enforce yung laws against piracy ng kahit aling nation, di ba? Slave trade. Authorized broadcasting in the flag state of the warship has jurisdiction. If the vessel has no nationality and that the vessel has the same nationality as the warship, regardless of misrepresentation or concealment. Passage. Dumaan ka lang. Navigation through the territorial sea for the purpose of traversing that sea without entering internal waters, calling at a roadstead or port facility outside internal waters and proceeding to or from internal waters, or a call at a roadstead or port facility. So, ano ba yung roadstead? It's a place less enclosed than a harbor where ships may anchor. So, innocent passage. Innocent passage is a passage of a foreign ship that is not prejudicial to the peace, not prejudicial to the peace, good order, or security of the coastal state. Dumaan lang, innocent, walang masamang balak. The right to innocent passage is a customary international law, thus it is automatically incorporated in the corpus of Philippine law. However, the following are considered activities na hindi innocent passage and therefore prejudicial to the coastal state. So no, bad to. Any threat or use of force against the sovereignty, territorial integrity, or political independence of the coastal state, or in any other manner in violation of the principles of international law embodied in the United Nations Charter. Any exercise or practice with weapons of any kind, any act aimed at collecting information to the prejudice of the defense or security of the coastal state, any act of propaganda aimed at affecting the defense or security of the coastal state, launching, landing, taking on board taking on board any military device. the loading or unloading of any commodity, currency, or person contrary to the customs, fiscal, immigration, or sanitary laws and regulation of the coastal state, any act of willful and serious pollution, any fishing activities, the carrying out of research or survey activities, and any act, ano ba tong notes ko? Ang daming mali. Any act aimed at interfering with any systems of communication or any other facilities or installation of the coastal state, and any other activity not having direct bearing on passage. So, mga bad to. Mga hindi to innocent. Okay, bad passage. Gawa-gawa ko lang yung bad passage. Walang bad passage. Basta hindi yan innocent passage. So, the area encompasses the deep seabed and subsoil beyond the national jurisdiction of any state. It is administered by the International Seabed Authority, an autonomous organization of the United Nations with headquarters at Kingston, Jamaica. It is regarded as a common heritage of mankind to whom all its resources belong. Kind of like high seas. So, pero ito na yung mga, sa baba, seabed. RA 9552. So, ito yung sinasabi ko sa inyong RA kanina sa baselines. It is a statutory tool to demarcate the country's maritime zones and continental shelf under UNCLOS 3, United Nations Convention Law of the Seas, Part 3. It is not to delineate the Philippine territory. It is to localize UNCLOS 3, which prescribes the water-land ratio, length, and contour of baselines of archipelagic states like the Philippines and sets the deadline for the filing of application for the extended continental shelf. Okay, so pag-usapan naman natin yung UNCLOS. So it is a multilateral treaty regulating the CU's rights over maritime zones. It merely gives notice to the rest of the international community of the scope of the maritime space and the submarine areas within which the states... Okay, wait lang. Capital natin yung states. Kapag strict ako sa ganyan, sa pag-capitalize, kasi, di ba, pag sabi mong state, para ma-distinguish mo sa state, state as a verb, or state as a, state, the following, mga ganyan, sa state na, state. Anyway, which states exercise treaty-based rights like the exercise of sovereignty over territorial waters, the jurisdiction to enforce customs, fiscal, immigration, and sanitation laws, and the right to exploit the living and non-living resources in the Exclusive Economic Zone or EEZ and Continental Shelf. So under UNCLOS 3, there are two kinds of features. Those that are above sea level during the high tides, which could be islands or rocks. Inano natin yung difference ng island at rocks. Yung islands capable of human habitation, yung rocks syempre hindi. And those that are submerged during high tide. So anong Doctrine of Incorporation? Very important to. The moment a state enters into a treaty and such is ratified, the provisions automatically become part of the law of the land by Doctrine of Incorporation. Okay, so criminal jurisdiction of coastal states. The coastal state should not exercise criminal jurisdiction over crimes committed on board a foreign ship passing through its territorial sea, except, so kailan pwede? If the consequences extend to the coastal state, yung coastal state yung may-ari nung territorial sea. For example, sa Philippines. If it disturbs the peace and order of the territorial sea, if the assistance of the local authorities of the coastal state is requested by the master of the vessel or a diplomatic or consular agent, or if necessary in order to suppress illegal trafficking and crimes against all nations. So again, as a general rule, bawal, pero pwede kapag ito yung mga exceptions yung in-enumerate ko. The coastal state has no civil jurisdiction over foreign ships or a person on board such a ship. It protects the vessels from levy, execution, or arrest for the purpose of civil procedure, except if civil liabilities and obligations are assumed or incurred by the ship itself in the course or for the purpose of its voyage through the waters of the coastal state, subjecting itself to the civil jurisdiction of the coastal state. The flag state, ito muna. Warships and government vessels operated for non-commercial purposes are immune from the coastal state's jurisdiction kasi yung mga warship, nag-extend dyan yung jurisdiction ng state. So, territory yan ng state. Submarines and other underwater vessels shall navigate above water and show the flags of their home states. The flag state shall bear international responsibility and liability for loss or damage to the coastal state for non-compliance with the provisions and regulations of international law. So, discuss natin yung PCA case na mabilisan lang. Ito yung South China Sea Arbitration. So, on January 22, 2013, the Philippines instituted arbitral proceedings against China in a dispute concerning their respective maritime entitlements and the legality of Chinese activities in the South China Sea. In response, by a diplomatic note dated February 19, 2013, addressed to the Philippines, China expressed its rejection of the arbitration. In China's view, the arbitral tribunal did not have jurisdiction in the case because China's acceptance of dispute settlement under the UNCLOS, the basis put forward by the Philippines, was limited and excluded sea boundary delimitations and determination of historic titles. Since then, China has continuously refused either to accept or to participate in the arbitral proceedings initiated by the Philippines. The tribunal, however, did not see this as an obstacle. On October 29, 2015, it delivered its first award, finding that it had jurisdiction and on yung tribunal may jurisdiction daw sa case. And on July 12, 2016, its award deciding on the merits of the dispute. So ito yung July 2016 award. The award addresses three main substantive issues: the so-called 9-dash line ng China and China's claim to historic rights in the South China Sea, and the status of certain maritime features in the South China Sea, and third, legality of Chinese activities in the South China Sea. Because of jurisdictional limits, however, the arbitral tribunal did not deal with the matters related to territorial sovereignty over the disputed maritime features between the parties. That means that the tribunal did not decide who owned the maritime features located in the South China Sea. Kasi yung iba, iniisip nila na dahil sa PCA case, dahil sa arbitral award, atin na yon. Hindi nag-decide yung tribunal kung sino yung may-ari ng mga pinag-aagawang features sa South China Sea, such as, kasali doon yung Spratly Islands na kiniklaim ng China and ng Philippines or any other coastal state, kasi hindi lang tayo nag-claim sa Spratly Islands, yung mga katabing states nag-claim rin. So wala, hindi nag-decide yung tribunal kung sino talaga yung may-ari ng mga yon. The tribunal did not delimit as well the maritime boundaries between the Philippines and China in the South China Sea. So, yung issue naman sa 9-dash line, the tribunal dealt with the question whether China's claim to historic rights within the, these typos, within the 9-dash lines were in conformity with UNCLOS. It first observed that this area in which China claimed rights formed in the long historical course to living and non-living resources partially overlaps with areas that would otherwise comprise the exclusive economic zone or the continental shelf of the Philippines. So sabi ng tribunal, yung 9-dash line mo at yung historical mo, China, in-encroach niya yung EEZ ng Philippines, yung 200 nautical miles from the baseline ng Philippines na entitled siya dyan. Diba? So, napag-usapan na natin yung EEZ. So, nasa na ako? Okay. So, wait lang. Okay. Or the continental shelf of the Philippines. So, hindi lang yung EEZ, pati yung continental shelf ng Philippines na encroach. In the view of the tribunal, UNCLOS establishes a comprehensive maritime zone regime and allocates rights in these areas to the coastal states, yung state na nagpa-pertain yung say EEZ, diba? And other states in the areas of EEZs and continental shelves, the coastal state enjoys exclusive sovereign rights to the exploitation of living and non-living natural resources. So concerning the rights of other states in these areas, the tribunal found that UNCLOS does not permit the preservation of historic rights of any state. Kasi yun yung inaano ni China, na kanila yan through historic title. So sabi, bawal sa UNCLOS within the EEZ or continental shelf of another state. Therefore, after the entry into force of the UNCLOS, the historic rights that might have existed for China, yung historic rights nila before UNCLOS, nung nagka-UNCLOS na, bawal na. Si China kasi, part din naman na yan ng UN. Okay. So that means pre-existing historic rights no longer exist as they are not compatible with UNCLOS. Accordingly, the tribunal concluded that China's claims were contrary to UNCLOS and exceeded the geographic limits imposed by it. So as to the issue of the status of maritime features. Wait lang. May edit lang ako. Okay, status of maritime features. The tribunal determined the legal status of certain maritime features occupied by China in the South China Sea, determining whether these are islands, rocks, low tide elevations, or submerged banks is important because unlike fully entitled islands, yung rocks cannot sustain human habitation or economic life, and of course, ito yung pinaka-important, rocks do not generate an EEZ and ACS or continental shelf. So consequently, rocks do not rocks do not give rights to resource exploitation beyond their territorial sea. Furthermore, yung mga low tide elevations or submerged banks also do not generate any maritime zone. Kasi hindi yan isla. Isla lang yung pwedeng mag-generate ng maritime zone. Kasi sabi ni China, may bato kami dyan. Tapos meron din yung EEZ. Ganun. Hindi pwede. Kailangan island. So the tribunal found most disputed maritime features not to be capable of generating an EEZ or CS. It classified Scarborough Shoal as a rock. So yung Scarborough, hindi siya island, rock siya. And among those features in the Spratly Islands, it found Mischief Reef, Subi Reef, and Second Thomas Shoal to be low tide elevations. So hindi rin siya nagge-generate ng EEZ and CS. And Johnson Reef, Quarterton Reef, and Fiery Cross Reef to be mere rocks. However, contrary to the Philippines' position, the tribunal concluded that Gavan Reef and McKennan Reef are rocks that are not capable of generating an exclusive economic zone or continental shelf. So, yung Philippines may kiniklaim din ng mga iba doon, islands daw. Hindi, bato lang daw yon, sabi ng tribunal. The tribunal assessed the status of these features, taking into consideration their natural condition prior to human modifications. In respect, the tribunal emphasized that China's construction of installations and significant reclamation work, as well as the maintenance of military or governmental personnel or civilians, cannot enhance. Hindi pwedeng dahil lang nag-install kayo ng mga kung ano-ano dyan, nag-construct kayo ng mga kung ano-ano dyan, or nilagyan nyo ng army nyo dyan, or whatever. Hindi dahil dinevelop nyo yung isang bato, yung bato magiging island na. Hindi pwedeng ma-enhance yung feature ng status ng rock or ng low tide elevation to become a fully entitled island capable of generating an exclusive economic zone and a continental shelf. So as to the legality of Chinese activities naman, the tribunal also ruled on the legality of activities of Chinese officials and Chinese vessels in the areas of the South China Sea located in the Philippines Exclusive Economic Zone and Continental Shelf. And it concluded that China breached the provisions of UNCLOS, in particular by temporarily prohibiting fishing in areas of the South China Sea falling within the Philippines Exclusive Economic Zone, failing to prevent Chinese vessels from fishing in the Philippines Exclusive Economic Zone at Mischief Reef and Second Thomas Shoal, and preventing Filipino fishermen from engaging, ang dami kong typo, from engaging in traditional fishing at Scarborough Shoal. So, mga ano to, na-breach ni China, meaning mali. China, bakit mo pinagbabawalan yung Filipino fishermen na mangisda sa sarili nilang exclusive economic zone? Hindi sa'yo yan. So, ganun yung sinabi. So, bawal mong pagbawalan kasi ikaw wala kang right na magbawal dyan. Hayaan mo silang mangisda dyan, kanila yan. So, regarding China's construction of artificial islands, installations, and structures at the Mischief Reef, which is considered sa low tide elevation, which is part of the Philippines, nandun yun sa exclusive economic zone natin without the authorization of the Philippines, and tribunal also found China to have violated the UNCLOS. So, kampi sa atin dito yung tribunal. In addition, with respect to the protection and preservation of the marine environment in the South China Sea, the tribunal found that China breached UNCLOS since it failed to prevent fishermen from Chinese-flagged vessels from harvesting endangered species on a significant scale in such a manner as to destroy the coral reef ecosystem. Furthermore, the tribunal held that China's land reclamation and construction of artificial islands, installations, and structures in the Spratly Islands caused severe, irreparable harm to the coral reef ecosystem. So, hindi lang kayo nagtayo sa lugar na bawal niyong tayuan, sabi ng tribunal sa China. Hindi lang kayo nagtayo ng mga bagay-bagay na wala kayong karapatang magtayo dyan. Nag-cause pa kayo ng harm sa environment. Ganon. So, discuss ba natin yung state immunity? Kasama ba siya sa state? Sige, para yung next yung next episode natin is Declaration of State Principles na lang na. Okay, so, State and immunity of state from suit. Okay. Doctrine of state immunity. State immunity. So the state may not be sued without its consent. Hindi pwedeng kasuhan si state nang hindi niya gusto, nang walang consent niya. Because there can be no legal right against the authority, which makes the law on which the right depends. But this is not an absolute rule. Some instances when a suit against a state is proper are when the republic is sued by name, so against the Republic of the Philippines, when the suit is against an unincorporated government agency, when the suit is on its face against a government officer, but the case is such that ultimate liability will fall upon the government. So sa tao, kinaso kunwari, public official, pero yung magbabayad, in case na matalo yung public officer na yun, is ultimately the government. Okay? So public official kasi may be sued in his personal capacity if he acts beyond the scope of his authority or official functions. Pero paano if he acted within his authority or official functions? So in a way, since yung person na yan nag-act sa will ng state, so parang si state na rin yung sinu mo. When the state gives its express consent through general law or special law, and when the state gives its implied consent as when it enters into a contract in its proprietary capacity, whether by the acts jure gestionis, basta yun, or economic or proprietary acts na lang, like the state commencing litigation and the state entering into a contract, or acts jure imperi, or by exercise of sovereign functions, except when the state merely intervenes for resisting the claim. Failure to allege the existence of the consent of the state in a suit against it is a fatal defect. On this basis alone, the complaint may be dismissed. So, principle of sovereign equality of states. The above-mentioned doctrine applies to all states. So, since patas lahat ng states, bawal nimong isu yung isa't isa. Kasi anong authority mo isu ako or isubject ako sa laws mo, 'di ba? Parang ganon. Eh meron din akong sarili ko. In international law, immunity is commonly understood as an exemption of the state and its organs from the jurisdiction of another state. Kasi independent ako eh, meron na akong sovereignty, sasabihin ng state A. Sabihin ng state B na, okay, so wala akong magagawa. Kasi 'di ba, bakit i-impose ng US yung laws niya sa Philippines? Yung Philippines, kahit mas maliit tayo, we are a country of our own, 'di ba? Same sa Singapore. Dahil ba mas malaki sa Philippines, pwede ngang i-impose yung laws niya dun sa Singapore? Hindi ka pwedeng kasuhan si Singapore. Kahit maliit lang yan si Singapore, mas mayaman pa nga si Singapore sa atin. Pero kahit si Singapore, mas mayaman kasi sa atin, pwede ba nila tayong isu? Hindi. Kasi equal lang sila. Pare-parehas lang tayo state dito. Parang ganon. So, this is anchored in the principle of sovereign equality of states, under which one state cannot assert jurisdiction over another in violation of the maxim par in parem non habet imperium, which means an equal has no power over another equal. The doctrine of state immunity is also available to foreign states insofar as they are sought to be sued in the courts of the local state. So tayo bawal din natin gawin sa iba, sila bawal din kasi pare-parehas yung mga states. Equal lahat yan, regardless sino mas mayaman, sino mas malaki. Diba? So, yan. Classical or absolute theory, a sovereign cannot, without its consent, be made a respondent in the courts of another sovereign. Restrictive theory, the immunity of the sovereign is recognized only with regard to public acts or acts jure imperi of a state, but not with regard to private acts or acts jure gestionis. Suability depends on the consent of the state to be sued or to be filed cases against. Liability, responsibility that is undertaken by the person or entity it is adjudged upon. When the state waives its immunity from suit, it does not concede its liability to any cause of action. If there is no other relief possible but for the government to make due compensation, the doctrine of state immunity shall not ensue. The government cannot hide behind the cloak of immunity if acted against the Constitution. So may limitations din naman. Bawal din naman injustice. So consent to be sued. Waiver of immunity. By consenting to be sued, the state does not necessarily admit that it's liable. Pwede mo kasuhan pero doesn't mean that I'm liable. In such a case, the state is merely giving the plaintiff a chance to prove that the state is liable, but the state retains the right to raise all lawful defenses. Okay. The universal rule is that where the state gives its consent to be sued by private parties either by general or special law, it may limit claimant's action only up to the completion of proceedings anterior to the stage of execution. Disbursements of public funds must be covered by corresponding appropriation as required by law. So again, bawal lang magbigay yung state just because kailangan gawa ng batas yan, yung disbursement. Waiver of state immunity is legislative in nature, and therefore the same cannot be given by the President. Where no consent is shown, state immunity from suit may be invoked as a defense by the court sua sponte, or of one's own accord, at any stage of the proceedings, because waiver of immunity being in derogation of sovereignty will not be inferred lightly and must be construed in strictissimi juris. Okay, so consent. Express consent. It can be given only by an act of the legislative body in general or special law. It may not be given by a mere counsel of the government. Implied consent. It can be when the state commences litigation, it becomes vulnerable to counterclaim, except when the state intervenes not for the purpose of asking for any affirmative relief, but only for the purpose of resisting the claim precisely because of immunity from suit. When the state enters into a business contract in its proprietary capacity or a private contract, unless the contract is only incidental to the performance of a government function, or when it would be inequitable for the state to claim immunity. So ito yung implied consent. Municipal corporations are suable. It is because their charters grant them the competence to sue and be sued. Nevertheless, they are generally not liable for torts committed by them in the discharge of governmental functions and can be held answerable only if it can be shown that they were acting in a proprietary character. So GOCCs do not enjoy the immunity of the state from suit. A GOCC has a personality of its own, distinct and separate from that of the government. When a suit is against an incorporated agency has a charter of its own and possesses a juridical personality independent of the state. If its charter provides that it has the right to sue and be sued, it is an express consent and it is suable. This includes a suit for tort. If its charter is silent, inquire into its function based on the purpose for which it was created. If the purpose is proprietary, if the purpose is to obtain a special corporate benefit or earn pecuniary profits. It's suable, and it is governmental if it is in the interest of health, safety, and for the advancement of public good and welfare affecting the public in general. It is not suable. Basta pag private capacity siya, kapag mag-enter into a transaction siya na private in nature or for like profit or something, like entering into a business deal or something, then ano siya, suable, possibly suable. Pero kapag in exercise of its government functions for public interest, then it's not suable. When suit is against an unincorporated agency, and an unincorporated agency has no juridical personality independent of the state. When it primarily performs governmental functions, it's not suable without the state's consent, even if performing proprietary function incidentally. Thus, even in the exercise of proprietary functions incidental to its primarily governmental functions, an unincorporated agency still cannot be sued without its consent. Even if the office being sued is an unincorporated agency of the government, the defense of immunity from suit will not be availing if the only causes of action directed against it are preliminary injunction and mandamos. Kasi pag preliminary injunction, stop, huwag mong gawin yan kasi may maapektuhang rights. Mandamos is, hoy, kailangan mong gawin yan kasi duty mo yan. So, okay lang yung mga ganyan. The defense of state immunity from suit does not apply in causes of action which do not seek to impose a change or financial liability against the state. When it performs primarily proprietary functions, as a general rule, it is suable. An exception is when the proprietary functions are indispensable in its discharge of governmental functions, then it is not suable. So public funds are not subject to levy and execution. Such is true, and even taxes are not subject to execution. Public funds cannot be levied or executed unless so declared by a statute or a law. So another legal remedy kapag hindi mo ito magawa is that the claimant may file for a petition for mandamus to compel the enactment and approval of the necessary appropriation for and the corresponding disbursement of public funds. So gawin nyo. Parang ganon, parang order na gawin. Kasi hanggat walang batas yan na nagsasabi na pwedeng magbayad si gobyerno or maglabas ng pera, wala. Exceptions is where the law or ordinance appropriating a specific amount to pay a valid governmental obligation has already been enacted. And funds belonging to government corporations which can sue and be sued that are deposited with a bank, or if the funds belong to a public corporation or a GOCC which is clothed with a personality of its own, separate and distinct from that of the government. As a general rule, a government cannot be made to pay interest unless it is expressly stipulated, and this payment of just compensation. So, just compensation is pag nag-exercise ng eminent domain sa state na parang bibilhin niya yung isang property for a public purpose. Okay? Kailangan niyang bayaran yung private person na may-ari ng property noon. Hindi pwedeng kunin niya lang. Or erroneous collection of taxes, or where the government agrees to pay interest pursuant to a law. Again, the state cannot be sued without its consent. It cannot be made to pay without its consent without an enabling law. So, ayun. Sa next video, Declaration of Principles and State Policies. So, yeah. Have a great day.